Welcome to this tutorial video. This video introduces the domains self-determination, cultural integrity, and lands, territories, and resources of the Indigenous Navigators Human Rights and Environmental Due Diligence module. In this video, we introduce the concepts covered in this domain and the relevant human rights instruments. The first domain, self-determination, addresses the overarching framework for the protection and promotion of Indigenous peoples' human rights. It encompasses key rights such as the right to self-determination, the right to free, prior, and informed consent, or FPIC, and the right to non-discrimination, both at the individual and collective levels. As touched upon in Video 1 on key instruments and standards related to human rights and environmental due diligence, or HREDD, states have legal human rights obligations to uphold these rights across all relevant policies, including laws, plans, measures, and implementation frameworks that regulate business activities and operations. These obligations are reinforced by the UN Guiding Principles on Business and Human Rights, or UNGPs, which affirm that states must protect against human rights abuses by third parties, including business enterprises, through appropriate policies, regulations, and adjudication. The UNGPs also establish that businesses have a responsibility to respect human rights, including the rights of Indigenous peoples, and to avoid infringing on these rights. This includes conducting due diligence to identify, prevent, mitigate, and account for adverse impacts, and ensuring meaningful engagement with Indigenous communities through their own representative institutions and decision-making processes. As introduced in Video 1 as well, the UN Committee on Economic, Social, and Cultural Rights, or CESCR, in its General Comment number 24 on state obligations in the context of business activities, emphasizes that state parties must ensure that actual and potential adverse impacts of business activities on Indigenous peoples' rights are systematically addressed through human rights impact assessments. A specific category, or so to say, a subdomain of the domain self-determination is non-discrimination. This category is included in both the National Survey and the Community Survey. This category monitors the state obligations to ensure the full and equal enjoyment of rights and fundamental freedoms by Indigenous peoples, both individually and collectively, without discrimination. This protection is essential to enabling their right to self-determination. From a human rights and environmental due diligence, or HREDD, perspective, assessing whether legal protections against discrimination are in place is essential for identifying structural risks. If these protections are absent or inadequate, this may indicate systematic vulnerabilities that expose Indigenous peoples, both individually and collectively, to disproportionate harm from business activities. Questions in this category assess whether international and regional instruments which provide required protection of Indigenous peoples' rights, also in the context of business activities and operations, have or have not been ratified by the state in question, whether any recommendations have been issued from human rights mechanisms on the impact of business activities and operations on Indigenous peoples' rights and whether these have been implemented, and whether policies, plans, measures, laws, and implementation frameworks regulating business activities with regard to human rights and environmental impacts, such as National Action Plans on Business and Human Rights, known as BHR NAPs, or laws on mandatory human rights due diligence and impact assessments exist, and whether they include specific considerations for the rights of Indigenous peoples to, for instance, free, prior, and informed consent, also known as FPIC. A key analytical tool to understand potential impacts that business activities may have on Indigenous peoples and their rights are impact assessments. Impact assessments are a key component of human rights and environmental due diligence, or HREDD, as they help identify and address potential adverse impacts of business activities on Indigenous peoples before harm occurs. International instruments on the rights of Indigenous peoples, like UNDRIP and ILO Convention No. 169 on Indigenous and Tribal Peoples, specify that states should conduct social, spiritual, cultural, and environmental impact studies prior to any planned development activities that may affect Indigenous peoples. Impact assessments must be conducted in cooperation with Indigenous peoples' representatives. These questions mostly concern the national survey. In the community survey, most questions target the lived experiences of communities. For example, whether impact assessments have actually been conducted in their communities, and whether traditional knowledge and cultural values have been considered in impact assessments. A fundamental component of the right to self-determination for Indigenous peoples is the right to free, prior, and informed consent, also known as FPIC. Under this category, the focus is on the obligation of states to consult with Indigenous peoples in order to obtain their FPIC on policies, plans, measures, laws, implementation frameworks, and projects. Here as well, states have important obligations to consult with Indigenous peoples. For one, consultation must happen before adopting and implementing administrative or legislative measures related to business activities that could affect them, or before the approval of any project affecting their lands, territories, or other resources. Consultation must also be with the Indigenous peoples concerned and through Indigenous peoples' own representative institutions. Consultation must also happen in good faith with the Indigenous peoples concerned, meaning engaging in a process that is genuine, respectful, and aimed at reaching agreement, not just fulfilling a formal requirement. This is set out in Articles 19 and 32.2 of UNDRIP. Lastly, the objective of consulting Indigenous peoples must be to reach an agreement or consent on a proposed measure, as has been outlined by ILO Convention No. 169 on Indigenous and Tribal Peoples in Articles 6 and 7. The National Survey assesses whether the state recognizes its duty in national legislation to consult with Indigenous peoples to obtain their free, prior, and informed consent, or FPIC, whether the state has adopted laws or other measures that require impact assessments to be conducted on business activities that could have negative impacts on Indigenous peoples' rights to land, territories, cultural heritage, traditional knowledge, and culture, and whether there are procedures or measures in place that ensure this appropriate consultation, such as environmental impact assessments. The community survey assesses whether impact assessments are actually carried out, what they consider, and what the quality of consultation processes was considered to be. In other words, how inclusive were they and did they meet the requirements of the standard of FPIC? The second domain considers cultural integrity. This domain focuses on the cultural rights of Indigenous peoples, including the right to practice cultural, spiritual, and religious customs, and to maintaining and developing traditional knowledge and cultural expressions. UNDRIP outlines that Indigenous peoples have the following rights in relation to cultural integrity. Article 11.1. The right to practice and revitalize their cultural traditions and customs, which includes the right to maintain, protect, and develop the past, present, and future manifestations of their cultures. Article 12.1. The right to manifest, practice, develop, and teach their spiritual and religious traditions, customs, and ceremonies. The right to maintain, protect, and have access to their religious and cultural sites, and the right to the use and control of their ceremonial objects. Article 13.1. The right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expressions, and the right to maintain, control, protect, and develop the intellectual property over such cultural heritage, traditional knowledge, and traditional cultural expressions. Having these rights recognized is important for ensuring that the indigenous traditions, customs, and ceremonies are protected from exploitation or environmental degradation linked to business activities, such as land grabbing or pollution. This category appears in both surveys. The questions in this category assess whether indigenous peoples enjoy these rights in the context of business activities. This includes looking at actual impacts and potential impacts to individuals or communities' cultural rights resulting from business activities or policies. The questions include a special focus on whether some groups, for example, indigenous women and girls, within communities have been disproportionately affected, and whether policies, plans, measures, laws, and implementation frameworks protect the ability of indigenous peoples to practice their cultural, spiritual, and religious traditions, customs, and ceremonies in the context of business-related risks and impacts and measures. The third domain is land, territories, and resources. Land is central to indigenous peoples' identities, cultures, and spiritual practices. It is not just a resource, but a living entity with which indigenous peoples have a deep and reciprocal relationship. However, while land holds sacred and cultural meaning for indigenous peoples, it is often viewed by businesses primarily in terms of development and economic value. Indigenous lands, territories, and resources are therefore often at risk of being appropriated. This is, for example, often the case in energy projects, since more than half of the mineral deposits needed for the global energy transition, including lithium, cobalt, copper, and nickel, are found near or beneath indigenous lands. This can lead to adverse human rights impacts for indigenous peoples, such as displacement and pollution. This domain covers the following categories: recognition, protection, and adjudication of inherent rights to land, territories, and natural resources, disposition, removal, and relocation, and compensation, restitution, and redress. The first category focuses on the recognition, protection, and adjudication of inherent rights to land, territories, and natural resources of indigenous peoples. Related rights are recognized in international law, such as UNDRIP Articles 25 to 28 and ILO Convention No. 169 on Indigenous and Tribal Peoples. Article 26 of UNDRIP specifies that indigenous peoples have the right to own, use, and manage their lands and resources they currently possess. But Article 25 goes further. It recognizes their deep spiritual connection to the lands, waters, and territories they have traditionally used, which grants them the right to maintain the spiritual relationship in territories and resources that are no longer in their possession, but which they have owned or occupied in the past. Human rights treaty bodies such as the UN Committee on Economic, Social and Cultural Rights, or CESCA, in its General Comment No. 26 on land, and economic, social, and cultural rights, have also pointed to the importance of respecting the spiritual relationships Indigenous peoples may have with territories and resources. Questions under this category assess whether the collective rights of Indigenous peoples to lands, territories, and resources are recognized in national legislation and the extent of this recognition. The questions also help document whether there have been allegations of business activities that are currently impacting or have negatively impacted these collective rights, how these allegations affected Indigenous peoples' lands, territories, and other resources, and whether government policies, plans, measures, laws, and implementation frameworks supported or contributed to these alleged harms. The second category, dispossession, removal, and relocation, covers state obligations to protect Indigenous peoples against eviction and ensure due process in cases of evictions related to business activities. While business activities and related policies, plans, measures, laws, implementation frameworks, and projects can lead to competition for land, Indigenous peoples must be protected from forced evictions, and there must be due process in cases of evictions. This must include processes to ensure FPIC. Article 10 of UNDRIP clearly states that Indigenous peoples are not to be forcibly removed from their lands or territories, and no relocation should take place without the FPIC. This is reinforced in ILO Convention No. 169 on Indigenous and Tribal Peoples, Article 16, paragraph 1 to 3. Additionally, protection against forced eviction is a core aspect of the human right to adequate housing. This is a fundamental right protected under the International Covenant on Economic, Social, and Cultural Rights, or ICE-SCR. States have an obligation to provide all persons with a reasonable degree of tenure security that guarantees legal protection against forced evictions. Questions under this category monitor whether national regulations on displacement contemplate specific measures for affected Indigenous peoples or territories, and document experiences of Indigenous peoples being dispossessed, displaced, or relocated without their free, prior, and informed consent, or FPIC, due to business activities. Compensation, restitution, and redress. Business activities, such as those within the mining, agriculture, infrastructure, or energy sectors, often take place on or near Indigenous peoples' lands, territories, and resources. When these activities result in confiscation, occupation, use, or damage without free, prior, and informed consent, or FPIC, they abuse Indigenous peoples' rights. Ensuring adequate redress, restitution, and compensation is essential to uphold the human right to remedy. This right is affirmed in the UN Declaration on the Rights of Indigenous Peoples, or UNDRIP. Article 28.1 states that Indigenous peoples have the right to redress, including restitution, or, when not possible, just, fair, and equitable compensation for lands, territories, and resources taken or damaged without their consent. Article 32.3 obliges states to provide effective mechanisms for redress and to mitigate environmental, economic, social, cultural, or spiritual harm. Article 8.2b further requires states to prevent and remedy actions that dispossess Indigenous peoples of their lands, territories, or resources. The right to remedy is enshrined in binding human rights treaties, notably the International Covenant on Civil and Political Rights, or ICCPR, which requires states to ensure that anyone whose rights are violated has access to an effective remedy through competent legal mechanisms. Article 2.3. In the context of business-related harms, the UN Guiding Principles on Business and Human Rights, or UNGPs, reinforce that states must ensure access to effective remedy, Principle 25, and businesses must establish or participate in grievance mechanisms for affected individuals and communities, Principle 29. The UNGPs also set criteria for effective non-judicial mechanisms, Principle 31, and clarify that businesses must not undermine state efforts to uphold human rights, including the integrity of judicial processes, Principle 11 Commentary. The following are some of the key concepts referred to under this category. Redress refers to the state's duty to provide access to effective remedies when rights are violated or abused. Redress includes legal, administrative, or other mechanisms that can reverse unjust decisions, such as forced relocation, and provide restitution, compensation, or other forms of justice. UNDRIP Article 8.2 calls on states to provide effective redress for any action which has the aim or effect of dispossessing them of their lands, territories, or resources. Restitution is the act of restoring what was lost or taken. It includes the right to return and the right of indigenous peoples to return to their traditional lands. Compensation refers to what is given to make up for a loss. In the context of resettlement, international standards require that adequate compensation is in the form of lands of equal or better quality and legal status. UNDRIP outlines the need for just and fair redress and equitable compensation. Article 28.1. ILO Convention No. 169 on Indigenous and Tribal Peoples states that when return to traditional lands is not possible, Indigenous peoples should be provided with lands of equal quality and legal status to those that they previously occupied. SESCA General Comment No. 26 on Land and Economic, Social, and Cultural Rights also articulates a state duty in relation to compensation for non-material values. States have an obligation to recognize and protect communal dimensions of tenure, especially in relation to indigenous peoples who have a material and spiritual relationship with their traditional lands that is indispensable to their existence, well-being, and full development. Questions related to compensation, restitution, and redress are only found in the community survey. The main question assesses if adequate redress, restitution, or compensation was received for dispossession of indigenous peoples, or the use or exploitation of lands, territories, and resources due to business activities and related policies, plans, measures, laws, and implementation frameworks. Follow-up questions point to whether remedy adequately considered cultural, religious, spiritual, and environmental in some non-material values, as well as the needs and rights of Indigenous women and girls. The last category under this domain, environment, relates directly to Article 29.1 of UNDRIP, which sets out the rights of Indigenous peoples to participate in the use, management, and conservation of natural resources. The rights of Indigenous peoples to participate in the use, management, and conservation of natural resources are also reinforced in binding standards. ILO Convention No. 169 on Indigenous and Tribal Peoples, Article 7.4, clarify that states must take measures to protect and preserve lands and territories in cooperation with the indigenous peoples that inhabit them. This entails that states ensure that the impacts of business activities on indigenous peoples' rights are incorporated into human rights and other related impact assessments. SESCA's General Comment number 24 on state obligations in the context of business activities has expanded on this by explaining that if this is not done, states would violate their duty to protect covenant rights, for instance, by granting exploration and exploitation permits for natural resources without giving due considerations to the potential adverse impacts of such activities on the individual and on communities' enjoyment of covenant rights. Questions under this category monitor whether there have been complaints to national authorities related to environmental impacts on indigenous land, territories, and resources in the context of business activities, and whether there have been allegations of hazardous materials being stored, disposed of, or accidentally released on or near indigenous land, territories, and resources. The questions can also help document experiences of indigenous peoples related to environmental impacts caused by business activities. Thank you for joining this video. Please explore the other video tutorials and materials on this page should you need further guidance in using the surveys and planning capacity building workshops.